Hello everybody, so welcome back to English Law. So I'm carrying on with tort and looking at the notion of fault. So sometimes there's some no liability, no fault torts, and there's still liability there. There could be intention, there could be carelessness upon the part of the defendant, and if a tort action proceeds, then if this can be proved when the defendant's liable. Now carelessness is the main type of fault in tort. So somebody is at fault, and then the claimant can successfully get compensation. So it really dominates. So tort is often about negligence, neglecting to do what you're supposed to do. So tort is really has fault as something central, but it was scarcely there in 19th century cases. It was only in the late 20th century that it became so dominant. In the 19th century, you had to prove a clear connection between defendant's act and the claimant's loss. The principle for tort is these days is that losses lie where they fall unless there's a good reason to move the losses elsewhere. The fault of the party causing harm is usually the reason for moving loss away from where it falls. So how do we become so preoccupied with fault? So that's not just in tort. There's a book about the wrongs of tort about it. And in this book, it says the element of fault was brought into tort because judicial thinking underwent a revolution. Sorry, not so much as a judicial thinking revolution, but because of a social need, which is a revolution. Because things became a lot more complicated. We stopped being mostly farmers and worked with technology. So the Industrial Revolution meant there were all sorts of new risks. You could get injured working in a factory, a coal mine, a dockyard, and so on. So they mass-produced lots of goods. There were railways and so on, and this meant there was a chance for people to be impacted by faulty behaviour by others, all the passengers of the train, for instance. But business coming out of the Industrial Revolution meant that there were lots of companies, and they were very complicated, huge organisations. Their management structure wasn't always clear. So ascribing responsibility is simpler when people are injured in workplace accidents if there's a company to sue. So societal attitudes have undergone a shift, and this attitudinal shift has gone away from individualism towards social and civic responsibility. The government has more and more found itself responsible for the welfare of people, especially after 1945. So there's a policy consideration whether the law of tort is serving public policy sufficiently. So we have to consider to what degree liability should be grounded on fault. So the tort system in the United Kingdom is supported by numerous different kinds of compensation. So there's state benefits, disability benefit through the social security system, and this is fast and it's quite straightforward to access. The tort system is also supported by liability insurance, and this is supplemental to the governmental system. It's something which helps compensate victims. The tort system is mainly about full compensation in as much as was possible. So the victim can make a tort claim, and they can recover a lot more than those who don't, who are just relying on the state. Compensation in tort is all about finding someone who's at fault. The claimant has to prove the defendant was at fault, and that led to the injury. So tort compensation is connected to earnings, and it also takes into account the loss of promotion prospects and things like that, how much you've suffered, loss of amenity. So it's similar to so it's not similar to Social Security. The amount of compensation is not limited, but if the claimant is not able to prove is at fault, then they have to rely on some other sort of compensation, social insurance, or the social system, or private insurance. So the Social Security benefits, you don't have to demonstrate there's any fault here, just that you are injured. So and the purposes of compensation provided by Social Securities are different from those in tort, because the tort is about full compensation. The Social Security system does not try to fully compensate you. There are these objective criteria, and it's nothing to do with earnings. The benefit in receiving receiving the state benefit is that you don't need to show any fault, and that's different from tort. Social Security is paid monthly. So the objective here is to make it less likely that there's double compensation. Okay, now there are some difficulties surrounding the fault principle as the core of liability. So the tort system has been castigated because it's less effectual than other possible systems, and litigation costs are very exorbitant. So the system is cumbersome, and it is going forward at a snail's pace. So if you emphasize fault, the trouble is then we're not sure if there's fault a lot of the time. It's very tricky to get an agreement about whether the defendant was careless, and the entitlement to how much compensation they get depends on how convincing the evidence is that's evinced before the court. But there are some exceptions. A very small number of negligence claims for personal injuries are hammered out through agreement. So, and then that's got to do with the bargaining positions of the two sides. So if you're trying to get compensation, this is also contingent on your financial resources. How much can you afford to pursue this action? Many of these successful claims in area like medical negligence, road traffic accidents, industrial accidents, where the defendants are either wealthy or else they're insured. So the fault system is probably unfair to claimants. It's also adversarial, and that means that litigation is highly unpredictable, and claimants try to settle actions so they pay out less than if there was a trial. So the system has been denounced by Lord Pearson of Rannoch. He sat on the Royal Commission for Civil Liability and Compensation for Personal Injury in 1978, and he said the system was very tricky for an injured person to comprehend and navigate. He said that because it's so adversarial, this really wrecks families, it breaks up friendships, and it ruins employment relations. So courts are loath to promote a compensation culture. I mentioned Tomlinson against Congleton Borough Council, 2004, because if we have this compensation culture, then we have to find someone to pay for the injuries, and that's the public purse. So then people are going to be very risk averse. Schools are going to stop trips, because if the people get injured, they'll be sued to kingdom come. Nursing homes or so on, or orphanages or whatever, saying, well, we can't because the liability insurance is just ruinously expensive. So there are other problems. Family doctors are going to send people for specialist treatment who actually don't really need it, just as a very slight chance to cover their arse. And then the specialists are going to be clogged with people who don't need to see them, and the patients who actually need to see them don't get seen on time. So there are all sorts of adverse effects by being unduly circumspect. So in Marovsky and Guy's Hospital, NHS Trust 2016, there was a case about this. They said compensation claims in modern law are expressed. So here's someone who'd been an employee, said he'd been bullied, intimidated and harassed by his line manager, and the line manager was acting in the course of her employment. So damages were claimed from the NHS Trust because of the breach of the statutory duty under the Prevent Protection from Harassment Act. So the House of Lords had to ask whether the employer could be vicariously liable under the Protection from Harassment Act in 1997 for the manager's behaviour. To succeed under the Protection from Harassment Act, they don't have to prove the foreseeability of the injury that resulted. So they said that this claim could be brought to the House of Lords. The House of Lords then dismissed the NHS's trust appeal and said that the employer might be vicariously liable for a breach of statutory duty employs an employee if, in having considered all the situation, the test of fairness and justice was satisfied. So Lord Nichols observed that where the behaviour is enough to be tantamount to harassment, then the courts have to consider petty annoyances, some emotional hurt that people are going to encounter in daily life. Such are the vicissitudes of normality. But the court says obviously there's a distinction between the usual grief you suffer, and that's life, and what is actually harassment. Anyway, Baroness Hale of Richmond said the following: there is already concern amongst many of our legislators that the scope for claiming compensation, even for recognised physical injuries, has gone too far. The avowed purpose of the compensation bill currently before Parliament is to rein in the so-called compensation culture. The fear is that people will look to others to compensate them for all their woes, and others will then become unduly defensive or protective. So that's the problem with compensation culture. There's a better regulation task force looking into this. So the Better Routes to Redress report was published in 2004, and it said the compensation culture is not really true, and people have exaggerated this. So we don't want to have a go culture. Anyway, there's important case laws here. Cases in law here. There's the Compensation Act 2006 has advanced this. The Act is there saying that many noble activities will stop because they'll be deterred by compensation culture. I want to remind judges to think about their rulings very carefully. Think about the repercussions of their ruling if they're excessively generous in awarding compensation. Perry and Harris, 2008, that case, the court the Act wasn't specifically applied in this case, and the courts are loath to create this culture which is unduly risk-averse. And that was as per the decision of the appeal court here about a child's bouncy castle, and do the parents have to watch the children bouncing on bouncy castle at all times in case somebody gets injured? No, they don't. That would be unreasonable. Sutton against Siston Rugby Football Club Limited, 2011. So the Act was applicable here. The claimant was injured when he fell on a plastic object on the rugby pitch, so the object was not easily visible. The judge said the suggestion that a quick walk over the inspection of the rugby pitch was enough to satisfy the club's duty of care was reasonable. The club's appeal against liability was permitted. The Court of Appeal said that a reasonable walk over the pitch was enough, and the games of rugby are no more than games, and they are desirable within the Compensation Act of 2006. So we don't want to make them too difficult to run. Okay, that's enough for the moment. Toodaloo.